One's worldview choice also impacts constitutional governance and the judiciary's constitutional function in our republic. The American judiciary holds a special role in the constitutional order. As Judge Robert Bork observed, the judiciary's great office is to preserve the constitutional design. It does this not only by confining Congress and the President to the powers granted them by the Constitution and seeing that the powers granted are not used to invade the freedoms guaranteed by the Bill of Rights, but also, and equally important, by ensuring that the democratic authority of the people is maintained in the full scope given by the Constitution. It is clear, therefore, that the structure and the words of the American Constitution contemplate a judicial branch with no power to make or enforce laws. Again, let's review. Article 3 provides the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made, which shall be made under the authority, to controversies which the United States is a party, etc., etc. But listen, you list all those things in there in Article 3, and nowhere do you see any enumerated judicial power for the judiciary to amend the Constitution. It's undisputed, and it goes all the way back to an early case called McCulloch versus Maryland, that the federal government is acknowledged by all to be one of enumerated powers. You know what that means? Rather than granting general authority to perform all the conceivable functions of the government, the Constitution enumerates very specific powers to each branch of government. And that enumeration of powers also serves as a limit on the exercise of government power, because if it's not enumerated, if it's not listed, if it's not given to you, that presupposes that it's not there and that you don't have it. And in Article 3, it's not there for the court to change the meaning of the Constitution. They're supposed to take the Constitution and the statutes and laws and all the other things that I listed there as they receive them, not as they would prefer them to be written. The Constitution's express conferral of some powers makes it clear that it does not grant others, including to the federal judiciary. And we know that the federal government cannot exercise powers unless we, the people, have granted to the branch of government a power to do it. That means that the federal government, the judiciary, the legislature, the executive branch can exercise only those powers that are in there. And during the ratification process of the Constitution, Alexander Hamilton, he saw no threat to our representative governance from the judiciary as long as the judiciary stayed in its own lane. You know, as long as they, in wearing a robe, stayed in the role of a judge and did not say, I'm going to be a policymaker today, or I don't like what the law says, so I'm going to interpret it to mean something else. And so there's no threat to the American Republic and no threat to our representative governance from the judiciary unless it goes out of its lane, unless they get out of the lane that they are charged with staying in under Article 3 of the Constitution. Judges must respect the Constitution and laws enacted pursuant to the Constitution. Only then is power conditional on the favor of we the people. And only then is the law and the Constitution shaped by the people's collective will. It is then, and only then, that the Republic is an entity of the people, true to its name. The judiciary furthers the democratic institutional values of representative governance when it honestly interprets a provision to discern its truthful meaning. Let me say that again. A judge is furthering the institutional democratic values of representative governance when it honestly interprets a provision of the Constitution to discern its truthful meaning. The judiciary threatens the constitutional order when it fails to do so. So, the Constitution, in my view, assumes an objective worldview and legal philosophical approach to the Constitution that obligates the judiciary to honestly interpret constitutional and statutory provisions according to their true meaning. And by doing so, the judiciary may discern whether legislative and executive actions, either fall within the authority delegated by the people in the Constitution or whether they infringe on liberty guaranteed to the people by the Constitution. The judiciary and a judge in the judiciary ought never usurp the people's prerogative when interpreting constitutional and statutory provisions. Republican principles require unelected judges to merely articulate the true meaning of constitutional and statutory provisions when deciding cases and controversies under Article 3 of the Constitution. And when it goes further, when they make meaning malleable, when they decide to change meaning by way of their alienable worldview, a republic cannot function as a republic. It becomes something else entirely. Hamilton explained why this, malleable, organic, living constitutional judicial policy making by way of their alienable worldview improperly conflicts with the Constitution's design for Republican governance. Hamilton said, it can be of no weight to say that the courts, on the pretense of a repugnancy, may substitute their own pleasure to the constitutional intentions of the legislature. And I think we see that far too often these days, where a judge doesn't like what the people's representatives enacted. And the unelected judge that's just supposed to resolve disputes arising under the Constitution, because they don't like the law, instead of resolving the dispute, they change the meaning of the law to fit their own personal political preference. And then they resolve the controversy in front of them. That is a very, very, very dangerous road. Hamilton said the courts must declare the sense of the law. And if they should be disposed to exercise will instead of judgment, the consequence would equally be the substitution of their pleasure. And we see far too much of that, where the judge is substituting their own personal pleasure to that of the people's representatives. The American people, through elected representatives, we hold the ultimate power of the state. If personal preferences of politically unaccountable judges supplant policies of the people's representatives, government ceases to represent the people. As early as 1823, Thomas Jefferson, he observed the threat to Republican governance from judicial activism, especially judicial activism that deems the meaning changeable by way of their alienable worldview. Jefferson said, their decisions, seeming to concern individual suitors only, pass silent and unheeded by the public at large. In other words, we're not seeing it even happen because it's happening in a courtroom or in the chambers of a judge. And he says that their decisions nevertheless become law, even though nobody's seeing it because it's not being done within Congress where it's all transparent and it's all out there. Their decisions become law by precedent. And he says it saps little by little the foundations of the Constitution. And it works its change by construction before anyone has even perceived that this invisible and helpless worm has been busily employed in consuming its substance. He's talking about how the Constitution can be completely eroded through judicial activism that is not accountable or transparent to the people. Using an alienable worldview to judicially amend the meaning of the words in the Constitution bypasses constitutionally required political processes that specifically require involvement of politically accountable state legislatures and we the people. Where is that? Well, you find it in Article 5 of the Constitution, and the part of Article 5 that applies, it says that Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to the Constitution. Then it explains how that can happen. It also provides for conventions to change the Constitution. But again, it involves the people and the states. It is not anywhere in there saying that the judiciary, through the use of the judicial power, can change the meaning of the Constitution. likewise, using an inalienable worldview to judicially amend the meaning of the words in a federal statute, that likewise bypasses constitutionally required process that specifically requires involvement of a politically accountable people that are we the people. They're accountable to we the people, Congresses. And for a statute to pass, it requires the involvement of the Congress and the president, people that are politically accountable to the people, not judges under Article 3 who are not accountable to any person. Article 1 of the Constitution, with regard to statutes, for example, says that all legislative powers herein granted shall be vested in Congress of the United States, Senate, Representatives. Every bill which shall have passed the House of Representatives and the Senate shall, before it becomes law, be presented to the president. There's the process right there. Politically accountable policy. We don't like the policy. We hold them accountable to the next election. A federal judge, on the other hand, decides, I want to make policy. Well, what do you got? You've got a person that is appointed for life because they're supposed to be independent. And they're supposed to be independent so they can be completely outside of all politics. Although the judicial branch may hold the power to honestly say what the provisions of the Constitution or a statute truthfully mean, that power does not extend to amending or evolving the meaning of those provisions. The Constitution delegates that power to Congress and the president. And judicially changing the meaning of a constitutional provision or a statute usurps the people's authority contrary to those provisions. An unelected judiciary ought not improperly usurp we the people. I now want to spend a few minutes discussing the principle of judicial independence and how its abuse can threaten the judiciary's own institutional legitimacy. The Constitution expressly delegates lawmaking power to Congress, and the Constitution expressly delegates enforcement powers to the president. And when you read those delegations in the Constitution, those enumerated powers provide both the Congress and the president with the legitimacy they need to carry out their role under the constitutional republic. And so, for example, the president is the commander-in-chief of the armed forces. No one's going to question the legitimacy of a branch of government that holds the most powerful weaponry in the world. Congress has the power to tax and spend. And so no one's going to question the legitimacy of the exercise of congressional power. Those enumerated powers provide legitimacy to the people's branches of government, where the people's representatives and the president elected by the people are acting pursuant to the powers that we, the people, have given them. Unlike those enumerated legislative and executive powers, when we, the people, delegated power in Article 3 to the judicial power, that delegation of judicial power includes no specific enumerated power to the judiciary to carry out its constitutional role of merely resolving disputes arising under the Constitution and laws of the United States. Nonetheless, for some reason, we, the people, entrust the nation's judiciary to independently resolve disputes that arise under the Constitution and laws of the United States. Why does that trust exist? Well, that trust exists only because we, the people, continue to perceive the exercise of judicial power as legitimate. The judiciary's power to apply the rule of law, as expressed by the people's representatives, preserves that legitimacy. And to facilitate that calling, Article 3 inoculates the judiciary against political interference from the Congress or by the president. Well, how does it preserve against political interference? It gives the judges lifetime tenure on the federal bench. And so federal judges holding lifetime appointments get to do so in order that they may apply the law to resolve disputes without fear of political consequences. Let me say that again. Federal judges hold lifetime appointments so that they can apply the existing law of the land to resolve disputes without fear of political consequences coming from the president or from the legislative branch. And with constitutionally instituted independence, I've said it before, comes responsibility. The principle of independence only preserves institutional legitimacy of the judiciary if a judge exercises judgment based on what the constitutional provision or statute actually says, and not based on what the judge wills it to say. The judiciary's duty to adhere to the Constitution requires it to resist the temptation to use that independence of a lifetime appointment to impose its will over the people. And, I'm going to confirm this in future sessions. We, the people, are guaranteed politically accountable representative governance, not judicial governance, not unelected judicial governance. And so, any unconstitutional usurpation by the court of that authority undermines the judiciary's institutional legitimacy. And so if a judge fails to resist the temptation to use that independence to impose its will over the people, that naturally leads to a politically active judiciary. Judges must resist the temptation to use its independence to impose its will over the people. Because if they don't, they will just naturally become politically active. And there's no politically active role in our constitutional republic under Article 3. It's not there. And a politically active judiciary can jurisprudentially engineer a judicial coup if it's willing to weaponize its independence. And the way they weaponize its independence is they use their alienable worldview that says, I get to make it up as I go along. I don't have to be constrained by what the Constitution actually says. Judges weaponize their constitutionally prescribed independence when they use their living constitutional interpretation in ways that take away power that is reserved by the Constitution to the people's representatives in Congress or to the president. And once they've done that, they're like a military that's armed. And with their inalienable living Constitution approach to changing the Constitution, and all of a sudden you have an unelected judge, an unelected judiciary, and judges operating within that judiciary, operating in the shadows, using their, I get to make it up, an alienable worldview along the way. And they're not representing the people, but in a very stealthy way, they legislate from the bench. And for a while, they can maintain this illusion of legitimacy while at the same time evading accountability. But rather than letting the true meaning of the Constitution's words guide their decisions, judges take it upon themselves to decide what they prefer the Constitution to say. And corrupting the constitutionally approved independence designed to guard against political influence, we get an imperial judiciary reigning at the cost of its own institutional legitimacy. And so when politically unaccountable judges amend policy that is enacted by the people's representatives, it's not surprising when the people reject it as illegitimate and accuse the judiciary of weaponizing the law. So in opposing ratification of the Constitution, even the anti-federalists foresaw the threat to representative governance from an unchecked independent judiciary using their alienable, I get to make it up worldview. And you can read the anti-federalists, and there's, a long, expositions on why an unelected judiciary could be dangerous. Thomas Jefferson, on the other side of the debate, he was for the Constitution. He nonetheless likewise understood how an independent judiciary using that I get to make it up alienable worldview could lead to an abuse of power. He said the Constitution is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please. Independence can be trusted nowhere but with the people, Jefferson said. And so he was concerned about how the judiciary, if they go outside their role of saying what the law is and instead change it to say what they prefer it to mean. They had a concern. It was a legitimate concern that exists to this day. Jefferson's and the Anti-Federalists' concern over an independent judiciary undercutting its own institutional legitimacy continues to hold merit. The judiciary holds a solemn duty to uphold the rule of law. And this duty requires it to resist the temptation to use its independence to impose its will over that of the people using their I get to make it up as I go along alienable worldview. Let's now move to the issue and the importance of predictability in the law and the predictability problem of an alienable worldview and a judicially active approach to interpreting the Constitution. Predictability in the law is a vital component of constitutional good governance under the rule of law. We want consistent judicial decisions that are grounded in honest interpretation, that give government notice of what is prohibited or what is prescribed. And when it comes to a judicial review of government action and constitutional provisions, consistent decisions provide predictability for folks seeking to act in accordance with constitutional standards. Now, an alienable, I get to make it up as I go along worldview, enabling judicially active, organic living interpretation undermines predictability because its subjective nature inevitably produces inconsistent judicial precedents. Instead of saying the law is A and the law will always be A unless we change the law, someone looks at A under the alienable worldview and says, hey, I don't have to say it's A, I'll say it's B. And then tomorrow the judge says, well, maybe it's C. And then the next day it's D. And then nobody has any kind of possibility of predictability with regard to the law is, and therefore does not know how to act in conformance with the law. And inconsistency is certain because judges using their living constitutional, judicially active interpretation make personal subjective assessments rather than looking at the true meaning, the true unchanging meaning of the provision or the content of the government action itself. And so you get inconsistent judicial precedents because it's all subjective. And it leads to unpredictability in the law, and it provides no beneficial guidance for anybody who is in government trying to act constitutionally, because the bar always changes based on whatever judge is writing the opinion. I want to finish this session addressing the tyranny problem of judicially active interpretation. The legal philosophical ammunition that judges use when weaponizing their independence by way of an alienable worldview is a living constitution, judicially active constitutional interpretation. The people that support the idea of evolving judicial preferences claim that through amending from the bench, judges can bestow new meanings and even new rights and understandings for the people. Well, it stands to reason, though, doesn't it, that a democratically unaccountable judge capable of giving rights and understandings is equally efficient at taking them away from you. And although it's possible to imagine how this power and this capability to quickly change the Constitution could be used for good by somebody, a stable, constant Constitution can do much more to protect liberty than any individual judge, even if that judge holds good intentions. And so the Constitution, to the extent its true meaning is upheld, provides the political structure necessary for a functional representative governance, all the while protecting inalienable liberty. This idea of judicially active, organic, so-called living constitutional interpretation enables politically unaccountable creation of new meaning It destroys constitutional structures. It destroys constitutional safeguards in our Bill of Rights. And so I would suggest even that a judiciary changing the Constitution's meaning to what a contemporary unelected judge wants it to mean, that's the first step on the path to tyranny. And as we will see in future sessions, that path to tyranny is littered with anti-Christian sentiment and disregard for the rule of law. Until next time, this is Professor William Wagner for Keepers of Liberty.